Hello and welcome to Friday Live. I'm your host for today. I am Strata lawyer Amanda Farmer. We are going out live to the Your Strata Property Facebook page, also heading out to LinkedIn. Special hello to our LinkedIn viewers and out to YouTube. We got a bit to share this Friday. It's great to be here, to have some time in the schedule to pop in and do a bit of a wrap up of the week that's been in Strata. So much going on in our Strata world, as always. Really, we've always got lots to share. We've got new law that started in New South Wales this week. The first round of our 2025 strata law reforms, 1 July 2025, we kicked off with those. There's more coming later in the year. Are you on top of that? Strata managers, committees, have you been putting your environmental sustainability motions on your AGM agendas? Have you changed the way that you are charging for records inspections? We've got some new fees for some people who are carrying out records inspections. We've had a bit of back and forth about whether we're GST inclusive or exclusive now with our records inspections. Have you worked that one out? Committee members, are you aware of the new statutory duties that you have, new duties set out in the legislation? I saw a post on LinkedIn a couple of days ago, lawyers and professionals posting about this new law regularly, at least those in my circles. And I saw somebody post, committee members, you now have the following new duties. You have to act honestly and you have to act fairly, and all of those additions to Section 37. And I thought to myself, well, it's kind of always been the case, right? That our Strata committee members need to be, under the law, because of their position as committee members, as fiduciaries themselves, should be acting honestly, acting fairly, acting in everybody's best interest, in the best interest, I should say, of the owners' corporation as a whole. That's now clear in Section 37. Shouldn't really need that to be set out in our legislation, but it's there. It'll be interesting to see how that one is used by the lawyers moving forward. Many of you coming in, there's so many eyes here already, and you're dropping me some hellos here in the comments. I see them. There's so many of you. Anna's telling me that she's finally back after an illness. It's great to have you back, Anna. Good to be here. Happy Friday to those of you who are wishing me happy Fridays as well. Keep those hellos coming. I always love to see who belongs to those eyeballs who are here live. And if you're catching the replay, I love to see your hellos come through as well. We always see those after the live session. We welcomed in lots and lots of new members into the Your Strata Property membership community just last week off the back of our Strategic Strata Litigator webinar. So if you're new to our world, if you are just hearing about the opportunity to be here live with me on a Friday and you're here for the first time, let me know. We always like to know who our first time viewers are and give you a special hello if you're new to our membership and you've been finding your way around and you've been poking around the Q&A forum. You've been having a look at the NCAT Vault. Let me know how you're going there. Been answering lots of questions from new members inside our forum over the last week or so. Welcome, welcome. Everyone is here, ready to go. Today, we're going to have a quick swing around to make sure you're aware. We have a podcast episode out this week and what that one is about. I'm going to remind you, though, depending on how closely you follow the news, you might be hearing this for the first time, that there is a parliamentary inquiry into strata management practices going on somewhere in this country. And the big ticket item today, some new law in the context of privacy. And you may not have heard about this one because it takes a couple of leaps to connect it to our strata space, but it is incredibly relevant. Once you start looking at it and realizing the impact of this new privacy law right across the country, it is incredibly relevant to our strata space because we're often talking about privacy rights and obligations when it comes to records, record keeping, record disclosure, record inspections in strata, and cameras, CCTV cameras, whether they're installed on the common property by the owner's corporation or whether they are installed by an owner who, for whatever reason, wants to keep an eye on things that may be going on the common property and may be going on other people's property. We talk about it a lot. There is now some legislation which changes the playing field, I'm going to say, a little bit in this area. So really, really important that we are aware of it, across it. That's where we're going to spend a fair bit of our time today. Keep those hellos coming. I see you all there. Hey, Kareem, how you doing? Kareem saying, I had to interrupt listening to your podcast to see you live. Yeah, well, when we get the podcast out, it went out a little bit later on Thursday. I was just making sure that those final edits were exactly where they needed to be in that last version of the file that went out to everybody. Went out a little bit later. So if you're catching up today, good on you, and over the weekend as well. Vicky, I see you there saying, hi, Amanda, great to be a member and to be able to join your community. Mwah, wonderful to have you with us, Vicky. And Suzanne, here on the CCTV cameras. Yeah, we're absolutely going to get into that. So podcast episode this week that Kareem was just listening to and just ripped it out of his ears and thought, I've got to go over and catch Amanda live. Episode number 456, a car-based side hustle. Has anyone got a car-based side hustle? Making some money off your unused car space, whether you're in Strata or perhaps in a house, freestanding home somewhere. If you live close to the CBD, if you live in an area close to transport, this might have crossed your mind. Might be able to rent out my car space, particularly when we're feeling the pressure, cost of living pressures, a little bit more cash in the hand might be helpful. That's what I'm talking about this week. And that was off the back of me sharing some comments with 9.com.au, 9 News website. Jono reached out to me and said, Amanda, I'm doing an article. I'm hearing that people are making up to $850 a month renting out their car spaces, but I'm very aware that there might be a few tricks here for people who live in Strata that they need to be aware of, need to make sure they cover off if they're going to rent out their space. So I always ask the journos how they find me. And Madison, it was, who wrote this article, said, Amanda, I just called out to the newsroom, who's our Strata person? And there was your name and a few listeners to the podcast in the 9 newsroom as well, which is awesome. So she gave me a call, to her credit, to be able to get that insight, really important insight now with so many of us living in Strata. What is the unique perspective and knowledge that you need to have if you're going to rent out your space in Strata. So that article linked under this week's podcast episode if you want to check out the article itself. But in the podcast chat, I'm really going a bit deeper than what I shared there for the article, talking about potential bylaws that might regulate parking in your building that you may need to be aware of if you're going to be leasing your space out. I even gave my opinion as to whether I thought those kinds of bylaws that might be restricting parking are valid, are legal or not. Bylaws that attempt to regulate, to ensure security and make sure the right people are accessing the building at the right time. Those bylaws might be in place and they may impact your ability to rent out your space, especially if you're renting it out to a non-resident. So I think it was a comment here on the Facebook page when I posted the 9 article. Somebody posted, I don't think you run into these problems if you are renting your space to a resident. Certainly the problems with access and making sure that this person who is renting your space, if they need an extra key or they need a fob to be able to access the building, you don't have that problem if you're renting to another resident. But there may still be some other barriers to you renting your space to somebody else. And one of those was pointed out in a comment, which I think is on its way to being published, to being approved on the website under the episode. I've seen it, but I'm not sure if it's public yet, but it will be. Somebody commented that if an owner is leasing their property or if a tenant is subleasing the property, there is an obligation under our New South Wales legislation to inform the owner's corporation of that lease or sublease. All the sections are flying around inside my head. Which section is it? I'm not gonna have a guess. I want to say 258. Don't know. Bingo. Anybody? I want to say 258. an investor, owner, a landlord, or their agent must notify an owner's corporation if there's a lease in place. And indeed, if there's a sublease in place, it is still the obligation of the owner or their agent to notify the owner's corporation of that sublease. So I didn't mention that in the podcast episode. Thank you. You guys are very good at letting me know the things that I missed, the things that I didn't mention. That is really relevant, and why it is so important for investor owners to know if their tenants are subletting. We should be informing the owner's corporation, and that is indeed how the owner's corporation might become aware that you are renting out your car space to someone who is not a resident. Even if you're renting out your car space to someone who is a resident, that is still going to be a lease or a sublease, and it needs to be notified to the owner's corporation. So great discussion that is coming out of that one. Anna, how you doing? Saying, regardless if it is strata or non-strata property, you need to make sure you're covered under insurance if you are looking to rent out car space or any other money making in the property. Yep, definitely. And I've mentioned that one in the podcast episode too, Anna. Susan, thank you. It is section 258. Oh, it's my lucky Friday. These numbers are burned into my brain. It only takes 20 years, guys. And then they change all of the sections on you, of course, unfairly. Thank you, Anna, as well. Section 258. All right, so have a listen to the episode. Yes, I do talk about insurance. I do talk about why you might not want to get involved in tribunal proceedings for your $850 a month. That might not be worth it. I talk about a range of different parking cases in Strata, not just relevant to renting out, leasing out spaces to non-residents, but I have a resource that I put together, I think it was last year now, when I spoke to ABC Radio National. Damien Carrick and I did a law report episode all about parking generally, and he asked me to prepare a list of cases from right across the country that touch on parking in strata, body corporates, strata companies. There's some WA cases in there. That free resource prepared for that purpose, and I'm sharing that one with you in this week's podcast episode as well. So have a listen. You'll get the link to be able to download that free strata parking resource. Henry saying, Amanda, renting a car space can be problematic if a car stacker is involved, being stuck by a non-inducted lessee. Yes. So learning how to use that equipment properly, having to be inducted into that process. It's just not simple anymore, is it? Not simple to rent out your space and think that it's come into the basement parking, park your car, go out again. Not necessarily how it's working in some of our more modern buildings. Good point, Henry. All right. Which state or territory is conducting a parliamentary inquiry into strata management practices? Do you know about this one? Who is it? It is the ACT. The Australian Capital Territory has been conducting this inquiry for a little while. I think it was back in March maybe that I first posted about it, and there was a call for submissions around that time. Anyone who would like to make a submission to the inquiry. Well, this week, the public hearings have been happening in Canberra. So the Legislative Assembly there is hearing directly from strata stakeholders. And look, I did a little bit of Googling. I have a bit of inside information. The Australian College of Strata Lawyers has a representative that is speaking at these hearings on the college's behalf. So I kind of knew that they were going on. But before today, I did a bit of Googling to just see if there's any news about this. And I've come across one ABC News article, which I will just share with you here on the screen. And we've got the link to that one for you if you want to go and check it out. Headline here, half of Canberra's bankruptcy filings last year were from strata managers chasing fees. Strata managers chasing fees and sending people bankrupt. You naughty strata managers. I didn't know that you had the authority or the power to do that. That's not quite an accurate headline, is it? Those of us who understand how strata levies work and who exactly it is who is chasing fees and possibly sending people bankrupt. This ABC article does have a particular bent, particular angle, let me say. Half of all forced bankruptcies in the ACT last financial year were the result of strata companies seeking money from unit owners with the territory figure well above the national average. Strata managers in the ACT. Let me tell you, an inquiry into strata management in Canberra has heard that some unit owners are struggling to afford increases to their quarterly payments, with advocates decrying a lack of financial hardship options. This is an old story. We've been hearing this for, I'm going to say, a couple of years now. We've definitely heard it loudly in New South Wales. Maybe it's the first time that it's being talked about in the ACT. The ACT Legislative Assembly inquiry is examining the effectiveness of current laws relating to the powers, qualifications, and licenses of strata managers, conflicts of interest, fees, and decision-making models. Now, that is a very different thing to owners' corporations in the ACT suing owners for unpaid levies. If you haven't yet noticed the tongue in my cheek, strata managers are not the ones who are chasing fees, chasing down owners in the federal court and sending them bankrupt. It is the owners' corporations who are owed the fees. And while the strata managers may act on the instructions of their client, the owners' corporation, it is not, as you may be forgiven for believing, reading this article and reading the headline, it is not the strata managers who are chasing down these fees or indeed being paid these fees out of these bankruptcies. So I think perhaps this paragraph here is a little bit more accurate. It is an inquiry into strata management practices, looking at powers, qualifications, licenses of strata managers, conflicts of interest, fees, and decision-making models, and looking at whether an ACT strata commissioner is needed. So again, look, this article just goes on to talk about difficulties with financial hardship, those who are in financial hardship and perhaps not having sufficient provisions in the legislation to account for that. This is where some cross-jurisdictional research, discussion is really, really important. And it's something that the Australian College of Strata Lawyers really supports and advocates for and tries to do, to make sure that those in other states and territories are aware of what others are doing. In New South Wales, we have, as part of our reforms, part of the reforms that have not yet started, but will start later this year, there's quite a new way that owners corporations are going to be required to set out their levy notices, a number of steps being taken in our legislation to protect those owners who are experiencing financial hardship, because all of this that you're reading in this ABC News article about the ACT, we've been talking about in New South Wales for a long time. So, I just found it interesting that the big ticket topic in the news coming out of this inquiry related to lot owners being sent bankrupt in reality by owners corporations, but on paper here by strata managers. I didn't think the inquiry was going to be focused on that exactly. What I haven't seen too much of is what SCA ACT is saying, or the position that it is taking in this inquiry. I had to do a little bit of digging for that, and I found a kind of off the beaten track article from I think it was called Mirage News or something like that. Someone else who's Googling this will be able to find it. Mirage News, I don't really know who they are. But happily, that article was quoting the president of SCA ACT, Chris Miller, and saying that SCA was emphasising the need for a strata commissioner, advocating for a dedicated strata commissioner, advocating for minimum education standards and requirements to raise professional standards to build consumer confidence through education, compliance, and accountability. SCA also has a focus on supporting sustainability, better access to government programs to help ACT buildings to adopt EV charging, solar, other environmental upgrades. So Chris Miller was quoted as saying, "A strata commissioner must be supported by a properly funded office, clear scope, and a plan to work collaboratively with industry and owners to deliver meaningful change." So the public hearing continues to take place in the ACT Legislative Assembly in Canberra. Lots of different strata stakeholders appearing there from across strata and housing sectors. Anna saying there should be a law against misleading news headlines. Look, I get clickbait. I get it. It's the world. It's the modern world. They want people to read their articles. We want people to open our emails. So, we can get a little teasy in the email subject lines and in the headlines. But that headline is wrong. Strata managers are not chasing fees. Strata managers are not sending people bankrupt. Okay, heading back to those hellos that are coming in and some comments there. Hey, Sean O, who is coming on in. I just want to head up to, I thought I saw, and I just scrolled past it, moving too quickly, a comment on LinkedIn. Liza, is it? Welcome. Liza saying property managers have a hard time giving out basic info like tenants' names and contact details for the strata role. Even owners fail to inform strata management that they are even renting. Yeah. And Liza, I don't know if you're across this, but this was a change. Oh, when was I talking about it? It might have been a couple of years ago because I was delivering a webinar for. No, I think it was last year. I was delivering a webinar for dual license holders. So those who held a strata managing agent's license and also a real estate agent's license. And a lot of people on the webinar were property managers. And because of that, I pointed out section 258 and I pointed out that it had recently, and I can't remember what it was, maybe the year before, it had recently changed to make the owner of the property responsible for informing the owner's corporation. But if the owner doesn't do it and they have an agent, so a property manager, then the agent is responsible for informing the owner's corporation that there is a tenant in place. So you have to kind of look closely at section, I think it's 258 that says this, to work that out. But it's important for property managers to be across that because it's a penalty provision as well. If it doesn't happen, then there's a fine that can be sought. So what I was saying to the property managers on the webinar is make sure that your client, the landlord, you've told them that, hey, we together have this obligation under this section to provide this information to the owner's corporation. Please give me your instruction and I will provide that information. Just making sure that you're all across that property managers, I don't know if you're a property manager, Liza, but property managers are across that obligation. Sean M, how you doing? Would be great to hear. So Sean M, if all states and national SCA boards and board members support licensing regimes nationwide. Yeah, I think the answer to that would be no, but that's anecdotal, I think, Sean. I don't think that's public information or information that those SCAs and representatives give out. Okay. Those comments are going fast and I'm getting a bit distracted by them there. So I am going to return to our agenda for today. And it is time. It is time to talk about this new privacy law that I gave a little hint about in my email this afternoon. New privacy law that started on the 10th of June. So it was only a few weeks ago. And there was a bit of a heads up about this earlier in the year that Privacy Act was changing, privacy laws across the country are changing because the Privacy Act is a national legislation that impacts the country. This particular change to the privacy law, as I said, just came into effect a few weeks ago, and I was alerted to this. I didn't know about it. I wasn't on top of it. I was thinking about strata law reforms at that time. I was alerted to this by a professional who is now a retired barrister. I would refer to him as a barrister, but he's now retired. So retired barrister who used to do a lot of work with me in the tribunal, would support me and my clients when we were preparing and prosecuting and defending NCAT applications. And we've worked together. I was a kid. I was 18, I think, when I met this barrister, and I was a law student and I was working in a practice that briefed this barrister. And so when I started to focus more closely on strata law, I have a joke that I essentially trained this particular barrister in Strata. And because I needed a barrister who would practice Strata, I taught him all about Strata law. This is how it all runs. This is how it runs in the tribunal. And over 20 years, we became quite a team. And like all good employees, you train them up, get them to know their stuff, they become excellent, and then they quit. That is what he did. He retired, well deserved after a very long career, but he does stay in touch and lets me know when I might have missed something, when something new is happening in Strata. Amanda, did you see this case? Sometimes it's Amanda, what was that section of the legislation again? This time it was Amanda, there is new privacy legislation. And do you remember that case we had years ago where you asked for advice about a camera? My client had a camera that they had installed in their lot property. They had installed it in their garden, right? And this happened to be their lot property. And they had installed it because they had an open terrace on the ground floor. They had a few balconies above them. It was a bit of a tower, a few balconies above them. And their neighbor above, who they were in dispute with about a number of different things, their neighbor above consistently had items that would drop down from their balcony to my client's terrace. And it was unclear who was doing this. And sometimes the cleaner was blamed and sometimes the contractor was blamed. But one Christmas, there was actually a dead rodent in a Christmas gift bag that just happened to accidentally drop down from the balcony above to my client's terrace below. Only in Strata, guys. So my clients got a little bit sick of this and decided that they would collect some evidence as to exactly what was happening, why it was happening, who was responsible for it. So they put a camera in their garden and the camera was pointed up to taking into their account, their property, and also to the balcony above. And when I think there might have been a sign in the lot area that said this is a camera. There was disclosure that the camera is there. And of course, the neighbor saw the sign, realized the camera is there and said, how dare you? You can't film what is going on our balcony. This is our private property. We have a right to privacy. You have no right to have a camera installed there that films what goes on our private property. My clients came to me. They said, Amanda, is this right? Are we breaching a law by doing this? We had a look at the bylaws. There's nothing in the bylaws about can't have a camera on our own property. It's not on the common property, so we don't need the permission of the owners corporation to install it. But is there some law, is there some surveillance device law, is there some privacy law that says we can't have this camera, which is recording only the video, not the audio, that we can't have this camera pointed at our neighbor's property for this purpose? I went, of course, to my teammate, barrister, said, hey, I've got this really curly question for you. Can you do some research and give us an advice? What do you think? And the advice that came back then, this is a number of years ago, was there is nothing illegal about this. There is no right to privacy that these particular owners have that is being breached by your client having this camera in their garden pointed up to the balcony above. They can do it. They're not breaking any laws. That ended up being the position that we took, and all went quiet from there on. So what I'm coming around to is that my barrister friend, retired barrister friend, then came back and said, Amanda, do you remember that case? And that advice that I gave, that it was okay to have that camera on your client's lot property pointed at their neighbor's property, that's no longer the case. It is not okay for them to do that now because there is a new statutory, that means it's in legislation, new statutory tort, a new statutory tort in the Privacy Act that allows somebody to take action should their privacy be infringed in that way. So I've used the word tort, T-O-R-T. I'm not talking about cakes and pastries. I'm talking about a civil wrong. A tort is a civil wrong. It is different to a criminal offense. But when I say there is a new statutory tort, the legislation is now saying this is a wrong that can be pursued. If someone is wronged in this way, they can be pursued under the privacy legislation, or their claim can be pursued against a defendant under the privacy legislation. This is new. This is a new right that Plaintiffs, those who are wronged, will have to pursue their right to privacy. And because of the exact example I've just given you of how this can play out in strata, this is really, really important for all of us to be aware of. What I'm going to do is share with you where this new legislation is, where this new statutory tort, this new legal wrong is in the privacy legislation. And there's a link for you as well. So I'm going to share what I have on my screen, which I have marked up, highlighted the important bits there for you so we can focus on those. But it is in Schedule 2 to the Privacy Act 1988. So I think the link to that via Ostly has just gone into the chat here. Schedule 2 to the Privacy Act. This is the new statutory tort for serious invasions of privacy. Now, this applies to all Australians. You might have heard me say before, you might have learned, especially if you're a strata manager running a business, you might have learned that the Australian privacy principles in the Privacy Act only apply to certain companies that have a particular turnover. And you've thought, oh, well, the APPs, the Australian privacy principles, don't apply to me. I want to be really clear that this new schedule and this statutory tort, anybody can use the protection of this schedule. Anybody can make a claim, can be a plaintiff with a cause of action under this schedule. Anyone can sue under this schedule. You don't have to be someone who is otherwise subject to the Australian privacy principles. So why is this new law being made? And there's kind of a nice summary here in the first couple of pages. The objects of the schedule: to establish a cause of action for serious invasions of privacy. So it's kind of recognized now in Australia that we haven't really had protections for those who are looking to assert their right to privacy. So I'm just a little bit distracted because my son is home from school and there's a lot happening there in the other room. I'm not sure if you can hear that too. That is the one of the objects of the schedule, to establish this cause of action for serious invasions of privacy. Some other objects there as well, which I'm not going to focus on here today. What I'm going to do is to scroll down to how exactly this works. What's the right that we're protecting here, and what action can you take if you feel that you have been wronged? Sean is saying, if the camera is not seeing into the private space, but seeing things emanating from the private property, is that a breach of privacy? Well, let's have a look. Let's have a look here, Sean, whether that's the kind of thing that this legislation is contemplating. So what I want to be clear about here is that this legislation does not really create new obligations. It's not like our strata legislation. I said earlier, we have new duties for committee members. Is that you've got to act fairly and you've got to act honestly and you've got to behave a certain way on the common property. It doesn't say that. What it does is that it gives somebody here, an individual, a plaintiff, the right to sue. The right to sue, that's a cause of action. The right to sue, to make a claim in a court if some of these things, any one of these things that's happening, that's listed here in this clause, is happening. So it's a right to take action. It's a right to take steps to protect your privacy and to seek damages, to actually get some compensation if you feel that these things have happened. So if you're an owner in a building, a resident in a building, and you feel like someone's had a camera trained on me for the last year, and I think that's a serious invasion of my privacy, until now you haven't been able to do anything about it. What this Schedule 2 does is gives you an avenue to do something about it. So that's what we mean when we say it's a statutory tort that's creating a new cause of action. All right, so the plaintiff, the person who is saying, hey, I'm going to sue you for this breach of my privacy, they have to show that the defendant, the person they're suing, whether that's the owner's corporation with a camera on them, whether that's their neighbor with a camera on them, has invaded their privacy by intruding on their seclusion. So I'm coming to Sean's comment here, where he's talking about what is it, what's going on inside the lot, or is it what's happening outside the lot? You have to have been intruding on a plaintiff's seclusion, misusing information that relates to the plaintiff. So it's one or both of those things: intruding on their seclusion or misusing information that relates to the plaintiff. So then we're talking about documents and information. And a person in the position of the plaintiff would have had a reasonable expectation of privacy in all the circumstances. You've got to prove that as well, that there was a reasonable expectation of privacy. So perhaps, it's somebody in their home. Do you think we have a reasonable expectation of privacy in our own homes? Yeah, I think that we do. And the invasion of privacy was intentional or reckless. We were meaning to record what was going on in that person's home with our camera trained on them. And the invasion of privacy was serious. And the public interest in the plaintiff's privacy outweighs any countervailing public interest. Is there a public interest in why I need to be getting this footage? Probably not in our Strata context. And importantly, the invasion of privacy is actionable. So there's been this invasion of privacy and you can sue because of it without proof of damage. So you don't have to have been injured physically by this. You don't have to have suffered any monetary loss. You don't have to have gone and paid lawyers to send letters. Even if there's no loss or damage, you can sue under this statutory tort. Okay, so it goes on to talk about countervailing public interests. I don't think these things are relevant in our Strata context. Maybe public health and safety might be. But I think if you're focused on public health and safety, that you might have CCTV cameras in common areas because of public health and safety, then that's not going to meet the requirement of being a serious invasion of privacy or intruding on somebody's seclusion. It's not a camera on somebody in their own home. Without limiting the matters that a court can consider in determining whether the plaintiff would have had a reasonable expectation of privacy, the court can consider the means, including the use of any device or technology used to invade the plaintiff's privacy. So how are we invading the plaintiff's privacy? Are we using a camera? Is it a video camera? I think that's going to be a relevant consideration. What's the purpose of invading privacy? Are we filming somebody because they've been harassing us lately and maybe putting dead rats in Christmas bags and throwing them down to our lower level terrace? Is that the reason why we might be invading their privacy? I don't know if that's going to be a good reason or not. I suspect maybe it might not be, but maybe it's arguable. The conduct of the plaintiff, including whether the plaintiff invited publicly or publicity or manifested a desire for privacy. If the defendant invaded the plaintiff's privacy by intruding on the plaintiff's seclusion, the place where that occurred, and I just think this is part of the reason why this is just so relevant to Strata. These are people's homes. These are people's homes where I know it happens because I've heard you, because you've come to me, because you've said, Amanda, is this legal? And until now, I've told you, yes, it is. I know that there are residents filming other residents. And it has been legal. I think there's a real question to be tried here now. If someone was to, and I think they can, they've got an actionable case, bring a case under this Schedule 2 of the Privacy Act, tapping into this cause of action, they're going to be saying that the place where the intrusion occurred is my home. That is going to be relevant for the court to consider. If the defendant invaded the plaintiff's privacy by misusing information that relates to the plaintiff, what was the nature of the information? Did it relate to intimate or family matters, health or medical matters, or financial matters? These are all the kinds of information, the types of information that are in Strata records, that are placed in Strata records every day. How that information was held or communicated by the plaintiff, whether and to what extent the information was already in the public domain. So we've talked about this before. We're moving away from the cameras now and talking about the records that an owner's corporation might hold, that a Strata manager might hold on behalf of an owner's corporation. I've always said that is private information pursuant to the definitions in the Privacy Act. That may be sensitive personal information pursuant to the definitions in the Privacy Act. And some of our Strata management companies and some owners corporations may be subject to the Australian privacy principles because of their turnover, and they have to be alert to whether they are subject to whether they are holding personal information, whether they are holding sensitive information. I'm going to get into exemptions that exist, and there is a relevant exemption here for information that may be held pursuant to a law. But what I'm alert to at the moment is our New South Wales legislation. I mentioned at the top of today's chat the amendment to Section 37, new duties for committee members. And I thought it was a bit weird. You might have heard me say this a couple of weeks ago. I thought it was a bit weird that there's a new duty for committee members, and I've got the legislation here in my hands, to only use or disclose information obtained as a member, including information about the owner of a lot, as required to carry out strata committee functions or as authorized or required by law. So a new duty that committee members can only use information that they get as a member as required to personal information about another lot owner as required to carry out their duties or as required by law. And I thought, why does that have to go in the legislation? Are there really committee members out there that are misusing personal information, that are getting a letter from a lot owner about financial hardship and are then broadcasting that to the world? I've made the connection. Now, I think that insertion into the New South Wales legislation, I think that is a direct reflection of this new Schedule 2 statutory tort that says that if information relates to intimate family matters, health or medical matters, it's private information. And if that is communicated and it is considered a serious invasion of privacy, then this statutory tort may have been committed. So we want to make sure that if we have private, personal, sensitive information in our strata context, we are only holding that information, keeping that information, making that information available pursuant to the strata law, because the strata law allows us to make that information available. Or there's, of course, some other law. We don't like talking about other laws here on this platform, but some other law that might compel you to make that information available. But you just want to be making sure if you are publishing, giving access to, circulating private information, that you are doing so pursuant to the strata law in the strata context. And we'll get down to why that is relevant because, oh, look, here it is now, because there are defenses. If a lot owner says, you had my personal information, my personal financial hardship information. You knew because I sent you an email explaining what my financial problems were. That is personal information. I spoke about how much money I make. I spoke about my difficulties in my relationship. I spoke about the child support that I have to pay. I put that in an email, and that was circulated to the Strata committee, and it got mentioned in minutes of a strata committee meeting, or perhaps my neighbor did a strata search and that information was available to my neighbor on a strata search. That lot owner, because they're aware of their new statutory tort, their new cause of action under the Privacy Act, might say, I'm going to sue you, Owners Corporation, and maybe strata manager, for releasing that information. I have suffered because of that, and I'm entitled to some damages. There is a defense. Owners Corporation, strata manager, you have a defense to this cause of action if the invasion of privacy was required or authorized by or under an Australian law. That is it. That is your protection. The Strata Schemes Management Act requires you, Owners Corporation, to make available for inspection all records under the custody or in the control of the Owners Corporation. That's in our New South Wales legislation, all records. There's no redaction. There's no carve out for that. The only carve out at the moment is privileged information, legal professional privilege. If the lot owner inspecting the records is the opponent of the Owners Corporation in legal proceedings or potential legal proceedings, then legal advice can be withheld from them. But there's no carve out for private information, personal information. And indeed, it is a defense to one of these actions. If a lot owner brings one of these actions, that the owner's corporation, the strata manager, can say we were compelled to keep this information on our record. We were compelled to produce this information. We had to send it to the committee to be able to get instructions, and it is the Australian law, the Strata Schemes Management Act, that requires us to do that. So be very conscious of that defence. I don't think, well, you can have a read through the rest of these defences about whether the invasion of privacy was necessary to prevent a serious threat to life, health, or safety. Not sure that any of these other defences would fly if you are a lot owner filming, and I come back to the easiest example and probably the most common, filming another lot owner in their home, or perhaps filming something that's happening on the common property, depending on what part of the common property it is, depending on what's going on. I'm not sure that you'll find any of these defences very helpful to you. This is the part that talks about damages. The court may award damages to the plaintiff. You can get up to $478,000. That's the maximum monetary damages. It matches, I understand, the maximum limit for defamation, damages arising from defamation. But you don't need to prove that you've lost any money. It's an award, compensation, compensate for your suffering because of this breach of privacy. Court's going to have a look when considering the amount of damages to award, whether the defendant apologized to the plaintiff, if the defendant invaded the plaintiff's privacy by publishing the information, whether the defendant published a correction. So you kind of want to be thinking about all these things. If, oops, we can fall afoul of this, we might want to be doing these things fairly quickly. Whether the plaintiff received or agreed to receive compensation in relation to the invasion of privacy, whether the plaintiff or defendant took reasonable steps to settle the dispute. Those will all be relevant considerations for the court when trying to work out the damages that it should award. There is a time limit on when to commence proceedings. I think Vicky had a question about retrospectivity. We've got some clever cookies here tuning in. Proceedings have to be commenced before the earlier of 1 year after the day you became aware of your invasion of privacy. And I need to train the brain to start using those words now. I think I've said breach of privacy a few times. We're talking about invasion of privacy. A year after the day you became aware of the invasion of privacy, or 3 years after the invasion of the privacy actually occurred, whichever is the earlier. So some fairly tight limitation periods there. Vicky, that might answer your question about, how far back can we go if there was a problem with the records? When did you become aware of that invasion of privacy? When exactly did that invasion of privacy occur? They may be two different things. So there's two different timeframes there, and you look at the earlier of those timeframes. A few things here that go on about, I think that was, yes, exemptions for journalists, government exemptions, things like that, national security things. I'm not going to get into that with you today. Not sure I've got anything else highlighted there. As always, we will link a copy of my highlighted PDF, my highlighted Schedule 2. We will pop it into our member forum because our members have previously said, Amanda, we love your highlighted cases. We want access to those summary versions so we know the important bits to look at. We do make those available to our members. So the team will get a post up in the forum, Privacy Act, Schedule 2, Amanda's highlights, and you'll have the link to this one to be able to access it. A few other things before I just flick away into those comments. I might just keep that one up on the screen and just make sure that I have shared with you what I wanted to here. Look, there's a real balancing here of security and privacy. I know some of you in buildings with CCTV will be asking, well, hang on a sec, are we opening ourselves up here now to be sued by owners who say this is an invasion of my privacy? There are obvious legitimate security concerns that are being addressed by having CCTV in place. And I think having cameras at buildings for those reasons, for safety, for security, is going to be fine, is going to be completely defensible if you have to defend yourself. You just want to make sure that you've had a good think about where the cameras are, as I know you're already doing. how they're positioned. What are they looking at? What are they picking up? We got the cameras trained on the right areas for the right reasons. If for some reason there's a camera looking at a balcony or a window or can look into somebody's home, why? Why are we doing that? Does that camera have to be there? And I do think that the use of signage in the residential context is now becoming that much more important. I was asked this question in our member forum a few weeks ago. Amanda, is there a law about having signage? I could only find signage laws relevant to commercial premises. And I think my answer was no, not in the residential context. You don't have to have signage, but signage is often a good idea because it's a good deterrent for people. You want people to know that there are cameras. You want people to know that they are on camera. I think there are parts of this statutory tort, this new Schedule 2, that refer to the plaintiff having knowledge, the plaintiff being aware. Signage is going to help you to answer that claim if you've got clear signage there that there is CCTV, that it is in operation. It's essentially a warning there for people, even if you're in that residential context. Maybe we will now see lot owners heading off to the tribunal seeking urgent interim orders if they feel like there's a camera trained on them or trained on their home that doesn't need to be, and that it's an invasion of their privacy. Urgent orders to make sure that that stops. This is a new avenue, new cause of action, new piece of legislation that owners can rely on, that they can point to say, tribunal, this is a legitimate dispute that I'm having with my owner's corporation or with an owner in my building. The relevant law is Schedule 2 in the Privacy Act. I have this right to bring this action, and I want you to do something about it. Really important for our owners corporations who have CCTV in place to have clear bylaws about how that footage is managed, bylaws that deal with access to that footage, who can access it, on what terms, of course, cross-referring to the, any relevant law that may provide for access. And that relevant law is, of course, as I've said, the Strata Schemes Management Act, but being able to point to those policies, those procedures, especially if they're in the form of a bylaw, is really important. So has your committee got a CCTV bylaw in place? If you don't, you've heard me say it before, please do think about getting one in place. I did go and have a look at my template CCTV bylaw, which is new in our template library. It's only been there for a couple of months or so. And I know a lot of members and non-members have accessed that one. There's nothing that I'm changing in that template to refer to or to reflect this law. Remember, I said earlier, this law is not about placing any new obligations or any new duties on our owners or our owners' corporations. What it does is it creates an avenue for someone who is aggrieved, who feels that their privacy has been invaded. It creates a new avenue for them to sue, for them to exercise their rights, what they say is their right to privacy. So what you want to do is just be prepared. Just be prepared that those claims, if you're an owners corporation, might come at you if you have CCTV in place. So you want to make sure that when you've installed your CCTV, you've thought about the right locations. And in my template bylaw, we do have provision for a map to be annexed, making very clear the locations of the CCTV. Also making clear that the owners corporation can have authorized representatives who access the footage, who arrange access to that footage, that there may be rules and policies made from time to time about access to footage, about how long footage is kept. So the template is drafted quite broadly there for you to be able to implement your own policies and procedures around it, and to be quite flexible with how it applies in your own building. But it will remind you of those things that you should be thinking about to be able to withstand, to be able to respond to be able to defend a challenge that might come at you under this new legislation. So members, you've got access absolutely for free. You can download the CCTV bylaw from our bylaw templates library. You'll know where that one is. And if you are not a member and you want to get your hands on the template CCTV bylaw that I have, then you can visit our templates page where all of my templates are available there for individual purchase. Okay, lots going on in this chat. There's a lot that I wanted to get across to you. And as you might have picked up, it's not necessarily straightforward. So I'm going to jump in and see where the questions are here and where, if there's any confusion, if I can help you with that. Kerry saying if the strata is separate villas and the camera's pointed downward to their own doorway only. Yeah, so that is where it's like a doorbell camera. You know, you want to know if there's delivery people or people coming into your property. That again, that's a security reason, right? You are going to be opening your door to somebody. You want to know who's standing there on the other side. I think that would be okay. Not okay, I think, where your camera is pointing at the doorway of your neighbor across the hall and you're seeing can see into their property as they come and go and open and close their door. That's not okay. So good example there to raise, Kerry. It's all about this balancing, reasonable, necessary. Is it necessary that my camera points down and looks at my door and my floor mat? Well, yeah, because that's how I see whether someone's standing at my door. It is not necessary that the camera goes any wider than that for me to be able to identify who it is that I'm opening the door to. So Karen was asking about where can you sue? Court only, not a tribunal. Yeah, Karen, I know I said we might see owners, this might have come up later than your comment, we might see owners bringing urgent interim applications in the tribunal, exercising this cause of action. I'll have a closer look at that, whether there's anything in this schedule that would require the action to be only brought in a court. I don't know that that's in there. If I miss that, I'll come back and just clarify that in answer to your question about whether the tribunal, this is the question, right? Whether the tribunal in each of our jurisdictions has jurisdiction to make orders under this schedule, whether this cause of action can be brought in our tribunals. I'll check that for you and come back to you. Thanks for asking that. Jennifer saying, what about if malicious damage is observed on common property CCTV of one lot owner against another lot owner? Yeah, so again, it depends where the CCTV is located and what it's picking up. If the camera is filming somebody's lot property and there's an altercation on lot property between two lot owners and the owners corporation says, well, we want to do something about that. In the course of having this altercation, they damaged the common property and you want to produce that footage, you may be met with a claim that, hang on, we didn't know there was a camera trained on our lot property. This has been an invasion of our privacy. If, however, there is a camera on the common property in the foyer area and there's a sign that says CCTV cameras are operating in this area, warning, and there's an altercation on the common property and a mirror gets smashed, then yeah, I wouldn't have a problem saying owners corporation use that footage to prove that the mirror was smashed by this particular resident who had an altercation on common property. I don't think that that's a problem. It's all about where the cameras are, and if these cameras are on common property, letting people know that they're there. Sean saying, what about all those surveillance videos on homes which point out to other properties, not just strata? Yeah. So somebody who discovers in a freestanding home that there's a camera on my home, on my bedroom window, on my backyard, whatever it is, until now, have not been able to do anything about it. And this has been a problem on the international stage, right? So if you read through Schedule 2 and why it's come about, there's one of the objects in there is for Australia to meet their international obligations. So I haven't looked any further than that, but we've probably signed up to some international convention, some agreement that says that we need to be protecting our citizens' privacy. And it's always been a thing in Australia. I say a thing in legal circles, and you learn about it at law school. There's no right to privacy. People think that they have a right to privacy. It's one of those only in America things. We don't, and we haven't until now. While this is a cause of action, it is a cause of action in recognition that we have this right, or we should have this right, and it needs to be protected. And this is how we protect it. So yeah, it's all new. It's all new stuff. Jennifer saying, what about if the camera is filming somebody's lot property and there's an altercation on common property? Yeah, so somebody who discovers in a freestanding home that there's a camera on the common property in the foyer area and there's a sign that says CCTV cameras are operating in this area, warning, and there's an altercation on the common property and there's a sign that says CCTV cameras are operating in this area, warning, and there's an altercation on the common property in the foyer area and there's a sign that says CCTV cameras are operating in this area, warning, and there's an altercation on the common property in the foyer area and there's a sign that says CCTV cameras are operating in this area, warning, and there's an altercation on the common property in the foyer area and there's a sign that says CCTV cameras are operating in this area, warning, and there's an altercation on the common property in the foyer area and there's a sign that says CCTV cameras are operating in this area, warning, and there's an altercation on the comm Okay, Liza saying, so here's where it can be tricky. Let's see how we go, Liza. Balconies which look down over a ground floor courtyard. Residents continually complain about the tenants disturbing the peace, having parties late into the early hours, smoking controlled substances, and the property manager asks you to prove it. Yeah, that's where it becomes tricky. That's where my clients with my rat in a bag, example, my client said, well, I'm going to prove it by putting a camera in my garden and I'm going to film what's going on in that balcony. 3 years ago, I said perfectly legal. Now I cannot say that, cannot give that advice. And I think if you're a lawyer or you're a property manager or you're a strata manager who perhaps may have been giving the same advice, just film it. I think you've got to be careful about that now, especially if you're filming into somebody's private space, into their home, looking very closely. And I think this schedule is worded in a pretty easily understandable way. Look quite closely at the circumstances that might give rise to this cause of action. Okay. Oh, I saw a word that's a comment that started with, I'm confused. Let's head there. How is the information, says Anna, being released when the email is just between the lot owner and the strata manager? Yeah, I might have got to that, Anna. What I was getting to eventually, and I hope I said, the information is then being accessed in a strata search. And that's where it suddenly concerns can be raised and are often raised. Strata managers, you'll tell me, are often raised that owners say, hang on, any owner or their authorized agent can access my private personal information when they do a strata search. And that is how the information gets accessed. But you've got a defense. The defense is we are required to give this access under Australian law. Okay. Ian saying, interesting information. Can I assume that there's similar legislation for Queensland? This legislation, Ian, applies in Queensland. This is national legislation. National legislation. So I haven't been as specific about the strata or body corporate legislation in Queensland, but in this respect, in terms of access to records and record keeping and CCTV installations, it's all quite similar to the New South Wales regime that I've been talking about. But yes, this privacy law, Schedule 2, new statutory cause of action can be used in Queensland as well. Robert, I think I've answered your question about the CCTV template. I knew I would get that one, so prepared that one for you earlier. No, I don't believe that my template needs any updating. I think what you should be doing if you're using that template is looking closely at those provisions that say, this is the location of our cameras. These are the we may set policies and procedures from time to time about access to CCTV footage, and we will inform owners about what those policies and procedures are. That's all there in my template, so have a close look at those. Okay. Thank you. Some of you talking to each other, answering your questions there. Anna, if you are in the membership, let's take this conversation over there to the forum, because, and I know you've got to go, because the questions that you are asking are all very good questions. And yes, emails need to be accessible in a strata search. And I can point you to a lot of helpful guidance around that question in the membership. It's one a lot of people have asked. So Liza saying, even if the police ask you to bring them evidence about the activities you are claiming, yeah, you've got to be really careful. I mean, there's a protection against self-incrimination when you are working with the police, but I would be saying to the police, look, I might have footage about this, but, I'm concerned that if this footage gets out, I'm going to be sued. I'm going to be sued under this new cause of action in the privacy legislation. So what protection can you offer me, police, if I'm going to give this evidence to you? And I think you'll find that there will be protections available there if it was to get to that situation. You've got some properties you're managing there, Liza, if this is a common one for you. Okay. I am going to finish up our chat there. I do want to come back and have a close look at those comments because this is new. We're getting used to it. We're learning. I do want to come back and address that question of what is the forum? So is it the court? Is it the tribunal? What is the forum in which people can be bringing these claims? Is it going to be as simple as a lot owner who says, invasion of privacy, release of my records, camera was on my door, invasion of privacy, I'm going to trundle off to the Consumer and Commercial Division of NCAT and get an interim order. If that's the case, I will let you know. If it's not the case, I will also let you know that. And keep those questions coming. I've just thrown it out there for you to start thinking about, start talking to your committees about if you're a strata manager. I think if you've already got cameras on common property, you just want to be comfortable that they're all pointing in the directions they need to point in for security and access purposes, and that you're not going to run afoul of this new legislation. Have a close read there of Schedule 2 to the Privacy Act. Thank you for tuning in. That was fun. I look forward to catching up with you all again soon. Until then, right now, go and have a fantastic weekend in Strata. See you, everyone.